Everyone. I hope everyone is staying safe and well through this time. Only two members of my court have contracted the virus, and both have recovered fully. The court is not meeting in person, and all of the staff are working from home outside the court and have been since March. We're getting ready to start 18 new law clerks in a couple of weeks, and it will be interesting to see how we transition to that. It was not so hard in March, where all of the legal staff was familiar with each other and with the court and with our processes, and now that won't be the case with a whole bunch of new people. So we'll see how that works, but we're expecting to have to work from home at least through the early part of the fall and maybe later into the year. Justice Green is retiring effective Monday, and we will miss him very much. He's been the senior justice for the last 7 years and has done a wonderful job for the court, both then and before. And he's really been a great contributor to the legal work of the court as well as to its administration. So we'll miss Paul a lot, and it's all the sadder because we don't have a way to celebrate. So he came by the other day at the court to drop off his key and his pick up some last things. And there was nobody there. So it's kind of, we've just got to find a way in the future to celebrate all these things that we've missed because of the pandemic. Sadder news still is that my good friend and former colleague, Gene Cook, passed away on Sunday afternoon. He had been ill and in declining health for a long time. We're sorry that his passing. His notable contributions, one of them to the court was he was the principal author of the Texas Lawyers' Creed and got both courts to pass it 30 years ago, and he was always very proud of that. Survived by his wife Sandra and his children Jean and Lori, and Gene tells me that they probably will not have a service, a memorial service for him. The court has put out 7 emergency orders since we last met 2 months ago. I'll just run through them right quick. One extends the bar dues deadline from August 31st till October 31st. A second one, the court extended the suspension of the statute of limitations so that deadlines that fell between March 13 and September 1 were extended to September 15th. And it's unlikely that the court will extend those suspensions further. We extended the pleading requirement in residential eviction cases. Many times an eviction cannot go forward because it's barred by federal law, but sometimes the tenants don't know that. Usually the landlords do. And so we have imposed a pleading requirement on the landlords to state to the justices of the peace that they know of no reason why the proceeding should be barred by the CARES Act or other federal requirements. And that's extended till September the 30th. You probably have all heard that we canceled the July bar exam. We did a thorough investigation. The Board of Law Examiners just concluded it was too dangerous to do so. We're going ahead with the September bar exam, but we're doing it in a unique way. The Board of Law Examiners has arranged for hotel rooms in 4 Hilton hotels, Lubbock, Austin, Dallas, and Houston, a hotel room for each taker of the bar. And it works out pretty well because the hotels are all desperate for occupancy, and proctors can walk the halls where the exams are being taken and kind of observe the takers. So we're hopeful that that will work pretty well. The October bar is to be online. That was added in the July order. I think it's going to be okay. There are three national companies that provide these kinds of tests online, and two of them have decided they cannot give something like the bar exam for various different reasons. But the third one is still going. There are about 30,000 takers signed up for the October bar across the country. So there's a lot of expectation that it will happen and will go off without a hitch. But we're all kind of working very hard to make sure that that happens. And then we extended what might call the Omnibus emergency order, our first emergency order, covering a lot of different areas and generally allowing courts to suspend deadlines and procedures. We extended that till September 30th. Jury trials are prohibited before October 1st unless you have approval from OCA. And OCA has developed a kind of a template, instruction manual on how to conduct a jury trial, what staff you need, how you have to arrange it, where the jury is going to assemble, all the various different logistical aspects of trying a jury case for judges who want to do so. Since March, we have had 13 jury trials in Texas. 2 were in June, and I think, I'm not sure there was one in July, and then the rest of them have been since. There are a number scheduled for trial in Houston. It'll be the first time there's been trials in Houston. I think there was one this week, and then there were a number that are scheduled in Houston, and we will see. About a large number, I think something like half of the trials that have been approved to be conducted ended up canceling for various reasons. There have been a couple of problems with jury trials. A couple of weeks ago, one was started in Brazos County, and the jail forgot to tell the judge that the defendant had tested positive previously. So I don't think anybody else out there involved in that has contracted the disease, but they're under quarantine. And so even when we know what has to be done, it's very hard to make all the pieces work right in this situation. We tried the first fully virtual jury trial in Justice of the Peace Nick Chu's court here in Austin in a misdemeanor case, traffic case, and it worked fine, and raises the question whether the 1,500 cases or so that are tried each year in the municipal and justice courts can't all be tried virtually at less expense and trouble for the parties in the court, especially since you're entitled to trial de novo in the county court in all or most all of those cases. So we're still experimenting. Last fiscal year, we tried 8,800 cases to verdict. And we, other than the 13 that I mentioned, we have not tried any cases since the middle of March. David Slayton estimates that we're about 1,900 criminal cases behind. So when we start to reopen, whenever that is, we're going to have a lot of cleanup work to do, and we face doing it at a time when the budgets are likely to be tight as well. So that's the status of the emergency orders. On rules, we gave final approval to rules requiring citation by publication. And then that was it back in June. Then last week, in response to the same legislation, Senate Bill 891, we approved service of citation by social media for comment. And so that comment period will last until December the 1st, and then the rule is expected to take effect December the 31st. That's one. Then we completed work on another legislative directive, rules governing the newly enlarged expedited actions category. The threshold was expanded by the legislature from 100,000 to 250,000. And so we changed the discovery rules, excuse me, in Rule 169 a little, to increase deposition hours from 6 to 10 in the current rule to 20. And we changed the rules to require mandatory disclosures, not just in those cases, but in all cases, per discussions that the committee has had. The comment period on those rules changes also extends to December 1st, and they are scheduled to take effect January 1st. And then this week, we issued a joint order with the Court of Criminal Appeals amending TRAP Rule 49.3 on motions for rehearing. And we studied all of the work of the committee very carefully. There were a number of proposals that were discussed by the committee. In the end, we chose to say that three justices should sit on all motions for panel rehearing except when there are two remaining and they agree. If there's 0 or 1 left on the panel, the Chief Justice assigns additional judges. If there's 2 of the original justices left on the panel and they can't agree, then the Chief Justice will assign additional judges. And then if there are 2 and they can't agree, no other justices would have to be assigned. So that's the change that we have proposed in the rehearing rule. And then we've had to delay implementation of the protective order registry. The committee discussed that at considerable length in November and February. As you will recall, there are a number of logistical and legal issues to navigate in setting up the protective order registry so that it works, and then also so that it does not impinge on important privacy rights. That was to be completed. It was to be set up by June the 1st and operational by September the 1st. The pandemic and the ransomware attack on the appellate courts have distracted OCA and required reallocation of resources to the point that they have not been able to meet those deadlines. The Judicial Council has extended the establishment deadline from June 1st to September the 1st, as the statute clearly provides. And then our court is extending the operational deadline. That's when courts will actually start regularly putting protective orders into the registry until October 15th. So there's been a little delay in that, but it's moving along, and I think we'll be able to meet those deadlines. That's what I have for an update, Chip.
All right, thank you, Your Honor. We will move on to the first item on our amended agenda, and that is amendments to the rules concerning admission to the Borough of Texas. I know that Susan Hendricks wanted to be with us. I don't know if she is or not.
She is, Chip.
Okay, great. Well, Nina, welcome. Susan, thank you for joining us. And as everybody knows, she is the executive director of the Board of Law Examiners. And Nina Cortella is going to lead our discussion on this again. Thank you. Go ahead, Nina.
Thank you, Chip. Appreciate it. So you all have the letter that Susan has written on behalf of the Board of Law Examiners. She's very aptly put out what the issue is and then what the proposed changes to the rules are. But basically, the issue is whether to change a conviction from a conclusive finding against character and fitness of the applicant to a rebuttable presumption. So that's the basic idea. I would like Susan to give us the background and reasoning for that. And when we have our discussion, I suggest we bracket it into two questions. One, conceptually, is the committee of the view that we should recommend a change from conclusive finding to rebuttable? And then secondly, we can talk about the actual wording that Susan has proposed. And let me say that we're very grateful, Susan, for you to participate. Susan is on vacation. And so
We all need it.
so, and I said, Susan, if you can be on for the first hour, that would be terrific. So it's time limited, but in terms of Susan's participation, we want to let her return to her family. But anyway, welcome, Susan, and thank you so much for taking time to participate with us. So let me turn it over to you to provide the background to this proposal.
Thank you, Nina. And I really do appreciate the committee allowing me to be first on the agenda. That's very generous of you, and I appreciate it very much. The background on this is this rule has been in place for a very long time. I think it's the corollary of it, I think, is Rule 11 of the disciplinary rules that you may be familiar with, that provides that if a licensed attorney is convicted of a felony, they may not reapply for admission to the bar until 5 years after completion of their sentence, whether it's probation or actual incarceration. So this rule is very similar, but it applies to people who are not lawyers at the time that their offense occurred. They're, you know, young people usually in their 20s who have get into some kind of difficulty and they have felonies. And the way the rule is written now, they can't even apply. They can't file a declaration as a law student, and they can't apply for admission to the bar. So many times we currently do consider waivers. For many years, the board took the position that this rule was immutable and that they could not waive it. There's a very general provision in Rule 20 of the rules governing admission to the bar that says that for good cause shown, the board can waive any of the provisions in the rules. But the board for many years took the position that this was a rule that did not appear to be subject to waiver. And that is part of the language in Rule 20, if it appears the rule is not subject to waiver. So they took that position on this Rule 4D2. And then at some point that was challenged, and the board was advised by the court that they didn't think that this was something that couldn't be waived. So now we do sometimes entertain requests to waive this provision. But in the judgment of the staff and the board, this is really not fair. I think you could even make some kind of a due process argument, because it's not apparent from the rule itself that you can obtain a waiver. It looks like a hard and fast prohibition that would prevent anyone with the felony of this vintage from even applying. So I think that many people may read the rule and be deterred and may not seek a waiver because they don't realize that that's possible. You know, if they call us and talk to us about it, we'll tell them, but they may not do that and they may not realize it. So many people on the board and applicants, and I think a few members of the court have thought that this rule was a little too strict and didn't give the board a real opportunity to exercise discretion depending on the circumstances of the offense and the person and all the different factors that you would consider. So this rule would just allow them to go ahead and apply. We would require them to appear before a panel of the board, and we would evaluate the circumstances before we would ever license anyone with a felony. So that's the background on it. Maybe that's too much information.
Not for this committee. Thank you for being so brief. Nina.
Thank you, Susan. That's really helpful information. And these were all points that our subcommittee did discuss, although we didn't have all the benefit of Susan's insights and So that's why we wanted just to bring it to the general committee. We had a range of positions on the subcommittee. So I will let our various members speak for themselves. I would say on balance, I think we lean toward making the change, but we certainly were not uniform in that view. Why don't I open it up for discussion either to the subcommittee or to others generally. And again, let's talk first just conceptually about the change, whether we are going to recommend to the Texas Supreme Court the change from a conclusive finding to rebuttable.
Yeah, you've got little buttons to raise your hands somewhere on your screen, and that would be the best way to do it if you can. But if not, then just charge on in.
I'm hoping at a minimum that our subcommittee will speak up because I know there are a lot of
Well,
people.
Robert Levy's got his hand up, and Lonnie, Professor Hoffman does as well. So, so we'll start with Robert, who's got it up just a shade ahead of Lonnie. Robert?
Robert, we can't hear you.
Can you hear me?
Yeah,
Yes.
we can now.
All right. Is there a concern that changing this to a rebuttable presumption will actually create a much more significant workload from the board in terms of evaluating the specific facts? Is this?
No, I don't think so. There's not that many people, you know, that overcome a felony to graduate from law school and apply for admission. There's not that many.
Okay.
But thanks for thinking of us.
Professor Hoffman, did you have your hand up?
Yeah, not much to add. Just quickly, it seems to me what Susan is saying is all the proposed change does is make the existing rules clear that waiver is indeed an option. That certainly seems like a better system than the one we have, and so I'm in favor of this change.
Great. Anybody else? Kenan?
I will echo Lonnie's sentiments. I am also in favor of the change. And what Susan said about the text of the rule not making it clear that somebody has this right is something that really stuck with me. It strikes me that some people may not even try because they don't know they can. And that's problematic from my perspective for a couple of reasons. One, it deters people from trying. And two, it's not consistent with the options that are truly available to them.
Yeah.
Okay. Anybody else have any comments? Justice Gray.
Also a member of the committee, and so I'll weigh in on the, you notice Nina's grinning, so you know I'm coming in on the other side of this, which is what she was baiting me for. The philosophically, it is, if the problem is people aren't aware of the waiver route, then let's just make it clear that a waiver is available if sought. That's a drastically different rule rewrite than changing the presumption. Having observed human behavior for a number of decades now, I see that people sometimes need a safe harbor. And I'm speaking primarily to the people that will be deciding these waivers. I know no members of the board, and so I'm not suggesting any of them are in the category that, okay, I'll just say it. The people need a spine, and they need some reason to decline a request when somebody's in front of them and they need something to hide behind. And if we are going to evaluate a felony in this regard, I don't see the need to change the presumption, make the waiver available. If you want to take the view, as current political philosophy seems to be shifting, and I've, for different reasons in the past, have seen the merit of this, but I don't see it here. But if you're going to take the view that they have served their time, they've paid their debt to society, then why evaluate it at all? Because remember, this is for 5 years after the conviction has been served and they've done their time. And so if you're going to have this presumption for 5 years versus the one way or the other, how it's going to be evaluated by the board, I just don't see the need for the change. They're not pounding down the door. It's not a burden on the committee. So if you feel compelled to make it more well known that there is a waiver available, then make it clear that a waiver can be applied for, but otherwise leave it alone.
Thank you, Judge. Anybody else want to comment on this conceptual issue?
I would say that one other suggestion that came up at the subcommittee discussion is if a bright line is desired still in terms of a conclusive finding, that you maybe tinker with it by limiting the years. That was brought up by Justice Gray's comment that it's now, there's a 5-year period, maybe make it a 2-year period. Just want to throw that out there. I thought that was an interesting.
Okay. Anybody have any thoughts on that?
I'll add 2 cents if I could.
Commissioner.
I do think it might be helpful. I generally agree with the proposal, but I do think it might be helpful to add something of a framework for what the calculus should be for approval, with maybe the obvious considerations being remoteness of the felony and seriousness of the felony. Right now, I do think it's something of an open-ended calculus, and that could be somewhat problematic.
If I could speak to that.
Yeah, certainly, Susan.
The board does have very detailed guidelines for decision-making in character and fitness matters that the board adopts separate from the rules provided by the court. And they do include all those factors for evaluation of anyone with any kind of a criminal history. The amount of time that's passed since the offense, the conduct of the applicant since the offense, the seriousness of the offense. And there's a long range of list of factors, and I don't have that document with me right now, but we do have a calculus, as you say, for the board to use in making these determinations.
Thank you. Roger.
Well, I'm all in favor of, if the board was granting waivers, then people ought to know about it. People at least ought to know what the practice is. I'm going to echo the suggestion that there be some basic minimums for waiver, just to avoid the argument that that waiver is being granted capriciously. And I'm talking about a time limit after the conviction or the person has done their time. I don't know that we can have a rule getting any more concrete guidelines than that, setting a floor than that. But I think at least some sort of minimum period might at least avoid the argument that it's being applied capriciously. Thank you.
Thanks, Roger. Stephen Yalanowski.
Yeah, I'm just wondering, I don't, obviously I don't, I haven't judged as a criminal judge and I haven't practiced law as a criminal defense attorney, but it occurs to me that if you lump everything into the category of felony, then you can talk about it that way, but there are felonies and there are felonies. And I don't know whether it matters for purposes of this rule, but I think we ought to think about it. And maybe some of it may be counterintuitive. I would be more concerned about somebody convicted of a felony of embezzlement than I would about somebody who was convicted at age 19 of some involvement in some kind of violence, frankly. The former is more of a risk to a client, probably. And so what we call felonies is a grab bag. And we should keep that in mind when we're talking about what ought to be done here.
Okay, good point. Anybody else on this topic?
This is Mike.
And then again,
I was part of the subcommittee as well, and I'm pretty much in Tom Gray's camp. Felonies are a pretty serious thing, and I think this topic should be treated with that degree of seriousness. I've served on a regional committee that approved people for the bar. I've served on the committee that approved people to take the specialization exam. And my problem with waivers is that they are invariably unevenly applied. And so if waivers are to be counted, I'm fine that we make it clearer, and I'm also fine with shortening the period of an irrebuttable presumption to 3 years, or say you may apply for a waiver after 2.5 years or whatever. But I'm just thinking, just turning it loose to the sort of the whims of the day and the appealing nature of any individual applicant probably isn't the best course to get consistent results.
Thanks, Mike. Kenan.
Just wanted to echo the comments that Judge Yalanowski made about there being a variation in terms of felonies. And I also feel that this is the type of rule that maybe we ought not apply the standard analysis to. More specifically, I mean that we often think about how big of an impact an existing problem has when assessing whether we ought to change the text of the rule. I'm of the mindset that there probably are some people out there who did some things when they were young. And if they're precluded from entering the profession for 5 years because of that, that could have a very detrimental impact on a life. And to me, if that has a really detrimental impact on one life, that's worthy of consideration. And I'll stop there.
Okay, Judge Esteves.
I'm going to echo the last two speakers, just because of the well, I've got a dog. Should I wait a second? I'm sorry.
And they're going to second you.
And I'm sorry. That's quite embarrassing because he doesn't even bark. So it must be a dog walking by because he doesn't bark at people. But I am going to echo them just because of the differences in the type of felonies. I don't think people are aware that right now, if a teenager or a college kid, age 19 or 20, drives off to Denver, buys a whole bunch of edibles, gets caught in Texas where they stop lots of cars going by, they are probably in the second-degree felony range for having a bag of gummy bears and 2 cookies or a brownie. And so we need to be able to differentiate on what type of felonies we're talking about, especially in that age group when they're more capable of doing stupid things. And then that 5 years hits right into your law school time. So, I think the rules are good, but I think that there's always room for flexibility for trying to determine, are these things that really are going to affect your law career, or whether or not you're going to be of a great the moral standard that we want. A lot of these things aren't crimes of moral turpitude, and yet they are felonies. So we need to just have some flexibility in that, however everyone determines that is. And I
Thank you,
apologize
Judge.
again for the dog. I'm going to go do something to him right now.
Oh, do it off camera, okay?
He's like 8 pounds. I'm doing nothing to the dog. So
Okay, any other comments on this? Nina, is there any other subcategory that we need to talk about on this rule?
No, I think what I suggest is a vote on conceptually what people think, and then regardless, let's look at the wording as well.
Okay, Stephen has got a comment before we vote.
Well, the elephant in the room is, of course, race, in my mind. I just looked up real quickly and I can't verify these numbers because I am not real sure of the source. So I'll say that up front about the reliability of the source. But for every one white person convicted of a felony, you have 4 African Americans. Another study says 3% of the population of whites are convicted of felonies and 15% of African Americans. And you could say, well, and I hope you don't say, that's just a reflection of more crimes percentage-wise being committed by African Americans. But even if you accept that, there's a huge overlap between race and income. And it's not surprising that there would be more felonies among a low-income population. So we're creating a presumption right up front that I think reflects a bias in the population. And whether that results in one presumption or another, I don't think we can just gloss over that.
Thanks very much. Any other comments either relating to what Stephen said or anything else before we take a vote? Yeah, Justice Gray.
I guess I would like to ask the chairman of the board that gave us the letter, if we just did away with the felony requirement or felony prohibition entirely and just let the board evaluate it in the context of their character to practice law metrics, what does that do for the way the rule is structured and the board would address this? Because I can kind of see where this train is going and I'm not willing to sacrifice for it. But what if we just took that out entirely? It's just another factor that gets weighed.
Well, if you want me to respond to that, what I would say is, I think that in some ways that is the effect of this rule. It would mean that because we can't control when they apply, they're supposed to file a declaration and tell us about this, but many times they don't. And so they're all the way through law school and maybe even pass the exam before they appear before the panel. And that is the point in time when they would, be making this determination. Many people want to get it decided early because they don't want to go through law school and borrow all the money and do all the work and then find out that they can't be admitted. But it varies. Sometimes they wait, or they come from out of state and they don't even know about this when they go to law school. So I think, honestly, Judge, that will be the ultimate effect of this rule change, is that it will be simply another factor, another important factor that the board will have to consider. And they do take a felony history very seriously.
Thank you. Any other comments before Nina frames a vote for us to take? I don't see any other hands up. So Nina, you want to try to take a shot at what we would be voting on?
Yes, the question for the committee is whether we are in agreement that the rule should be amended to convert what is now a conclusive finding to a rebuttable presumption.
Okay. everybody in favor of amending the rule to make it a rebuttable presumption, raise your hand. Pauline, you're going to help me count here.
Are we raising our actual hands or are we raising our virtual?
Yeah, do it electronically. That'd be easier for
I've
us.
done it both ways, just to be clear.
Does that mean my vote counts twice?
Right, mine too.
Yeah, probably.
I hate to admit this, but I don't know how to do it.
It's in the bottom right corner. If you open participants and it lists everybody, in the
Yeah.
bottom, it says invite.
Oh, I see.
And then
Okay.
hand.
Yeah, that would hopefully be a more accurate way of doing it, but if everybody's done electronically voting.
I've got to admit, I'm not seeing it for me.
People are still voting.
Oh, here.
Nina put.
I finally found it. Sorry.
All right.
I think, is it worth pointing out that nobody else sees the hands raised? I was confused about that before, but isn't that right? That people, whether they're voting up or down, essentially is a secret vote, which is fine. I just thought people might want to know that they don't see anything on their screen.
Right. Yeah, you'll see your
I
own
think
hand.
there's a little
can't-
blue hand.
You can't see the way people vote if you go to that list where you raise your hand.
Right.
Yeah, mine lists the participants and shows which way they voted, so.
Right.
Okay, thanks.
Hang on. All right, Pauline, what do you have as your tally?
I have 17.
Yep, that's what I have. Okay, 17 in favor. Everybody against, raise your hand. Your electronic hand.
And everybody who raised their hand to be in favor needs to lower.
Right.
Hand
Everybody
manual.
else lower.
Give it a few minutes because it takes a while for the lowering of the hands to register.
So we had 17 in favor. And Pauline, what do you have on opposed?
I have 5.
That's what I have. The chair not voting, so the vote is 17-5. The nays can lower their hands now. And Nina, what else would you like our committee to discuss?
Okay, the revisions themselves are reflected in 2 different provisions of Rule 4, which are attached to Susan's letter. So first, I would turn the committee's attention to 4D. And the revisions are in they're in all of 4D. The main ones are in 1, 2, and 3, the subsections. But so if there are any comments on this proposed resolution.
Can you tell us which tab of the documents this is? I've been looking for it tonight.
It's tab A.
Yeah, first tab A.
So Susan sent a letter dated January 7, 2020, and attached to it is a red line. It's page 2 of tab A. It essentially accomplishes what we've been talking about, but if there are any thoughts, which often this committee has on the actual wording, I invite those comments now. So we'll start first with 4D.
Well, I've got a question, Nina. You change, or somebody changes in the body of D, character and fitness to or fitness. What was the purpose of that?
Well, the reason for that is that character pertains to their whether they're honest, trustworthy, reliable, and fitness is more to do with their mental well-being. So those are not the same. A person could have a character issue and not have a fitness issue and vice versa. So it's just to distinguish between those two.
You got any, any comments about that language? Justice Gray?
I don't have a comment about the or. Mine relates to something else.
Judge Jalanowski, do you have anything about the or?
It sounds like the and before did treat them as the same thing, but to the extent it treated them as different things, it's a negative sentence, lacking in. So arguably, you had to be lacking in both before, and now with the or, you could be lacking in one or the other. I'm just talking about the meaning. I'm not saying what's preferable.
Okay. Any other comments on that?
Yes, I've got one, Chip.
Yeah, Frank.
Well, as I understand, you're retaining both good character and fitness. They both have to be satisfied. The places where you put, and that's where you say and. The places where you put or, as I understand, means that you're requiring separate consideration of each one. Am I correct that you still have to show present good moral character, which is like you're honest, and fitness, which is maybe, you can read, something like that. Those are different things, but you still have to satisfy both of them. Am I correct?
Well, you do, and that's provided in other portions of the rule. Fitness, as we use it in these rules, really pertains, usually it's substance abuse history is the most common fitness issue that we find, that we address in evaluating applicants.
Oh, really? Not good. That's not a good moral character issue.
No, we don't think of it as a moral character. It may, it may also, their conduct may also suggest poor character as related to that, but often it's just a simple matter of not being well enough to practice as a lawyer. And what we mean by, are they able to practice law? Can they read? Can they pass the bar exam? That's a competence requirement.
But they still got to really they got to satisfy all three.
Yes, they do.
Okay, one more question. You've changed it from been convicted to been finally convicted. And I'm not sure what that means. Does that mean when your felony conviction is affirmed by the Court of Criminal Appeals, what is finality? And it looks to me like if you haven't been finally convicted, you don't have to satisfy any of this.
Well, you're correct in your understanding of the change, but as a practical matter, if someone has a pending criminal offense that is yet to be adjudicated, even a misdemeanor, the board has the authority under, I believe it's Rule 15, to defer a determination on their application until that criminal matter has been finally determined. Because we're not in a position to really adjudicate the criminal charges. We can't conduct a trial on that. It would be, it wouldn't be an appropriate thing for us to do. And so we don't generally have hearings for people or approve them if they have a pending criminal matter, whether it's a felony or a misdemeanor.
Can you show us that rule?
Yeah, let me look here. I don't know if I can show it to you.
Oh, go ahead.
I think I can find it and read it to you. Okay, it's Rule 15B of the Supreme Court's rules governing admission to the bar. And it says, if there are pending proceedings involving the applicant or declarant, a declarant is a law student, the resolution of which could affect determination of his or her character and fitness, the board may exercise its discretion to defer the hearing until such time as the pending proceeding is resolved.
My comment is, of course, that's discretionary. And if the board chose to exercise its discretion and consider it, 15D under the present, if you say finally, 15D will simply not apply because it only applies to final convictions.
Well, I can tell you that they wouldn't do that, but I see your point that the way the rule is written, it's conceivable.
All right, that's all I have.
Thanks. Susan, on this issue of finality, what if there's a pending habeas petition?
We don't generally consider a pending habeas to be to affect the finality of the decision. But that, I guess that could be discretionary. A panel might decide that it does impact the finality.
What if the trial judge had recommended to the Court of Criminal Appeals that the habeas be granted?
Yeah, I think that would be an instance where they might decide that it's not final.
Okay.
I think the reason we added that language is that I believe we're deleting D3.
Okay. Professor Hoffman.
Thanks, Chip. So again, I like the intent here, but I don't know that the execution really succeeds. So sort of specific to this section D, which you asked about, I mean, it seems to me that we're going to end up with a rule that says an individual guilty of a felony is presumed not to have good moral character and fitness, and that it's likely to have the same effect that we're in right now, which is that a great many of the very small number of people to whom this applies are going to be deterred from even applying. There's no cross-reference here in any way to the special exception for good cause. And so I actually find myself agreeing with my good friend Tom Gray, even though we might disagree sort of about conceptually. I sort of like the idea of doing away entirely with a separate provision for treating people who have had felonies. If Susan, the practical effect of this rule is that the board is going to take into consideration sort of a holistic assessment, just as they would with any other applicant, well, then why have a separate rule about it then? Why, which especially if written this way, is likely to do the very thing you don't want it to do, which is misinform and deter people from applying for the exception.
Could have that effect. I think the thinking was that we wanted to signal to applicants that a felony conviction is still a very serious matter and that the board would expect there to be significant evidence of rehabilitation and a significant period of good conduct to overcome the presumption of lack of good character indicated by a felony conviction. I think that was the thought, just to give them notice that this is a serious element, because obviously the court, when they adopted Rule 4 originally, took that view.
So I give Chip, have just one quick follow-up on that. Is that okay?
Yeah, of course.
So that makes sense to me, Susan, if that's the case, and if that's the sort of prevailing sentiment, both on the court and on the BLE. But then I think we ought to say that in the rule, and there ought to be some sort of a reference to for good cause shown or something. Again, the problem with this revised version is no one's going to remember a few years from today. Certainly no one who is unrepresented is going to have any idea that the rule once said conclusively and now says presumed, and thus there's a small window of opportunity here. So I feel like this is a very good intent that will end up practically making no difference if we make the change that is being suggested.
Also, I would point you to 4F, which does have some, explains that that they have the burden to show that they should be licensed despite the felony conviction. So it gives them some guidance about what, as you're mentioning good cause, effectively what good cause might consist of.
Robert Levy.
I wanted to go to the language reference on taking out the and between moral character and fitness and changing it to the or. I'm concerned that this is a much broader issue, and the rule that you referenced, Rule 15, I believe, also uses the moral character and fitness. And I think it's a mistake to change it just here rather than doing a wholesale change throughout the rules to show that those are two different standards.
Okay.
Stephen. You're muted, Stephen. You're muted.
Yeah, got it. I was looking at the rule that's in the printed materials for somebody who's previously been determined not to be fit or of good moral character. And the way it phrases it there, I think it's subparagraph F, is that a person seeking a redetermination of present moral character and fitness, which means obviously that they were previously determined not to be morally of good moral character and fitness, then has to prove by a preponderance of the evidence. And then there's 1, 2, 3. Is that different from the presumption that we're talking about with the felony? Because why would they be different? And particularly, I imagine there's a provision for prior disciplinary actions. And so why would those things be different? As I said, felony is a grab bag. And at least with these things, we know whatever they did is directly related to the practice of law. So shouldn't that be considered? Are we being consistent?
Thanks. Justice Gray. Nina, do it mechanically. That'll put you in the queue.
Okay, all right.
The on the or question in D, to follow up on Robert Levy's concern, in D2, it is not changed. And so that seems to create an issue there. The addition of the word finally in the 4th line of D may have been intentionally omitted originally or not. There is an inherent problem when you start talking about felony convictions because of the community supervision. There are 2 different types of community supervision. There's probation and there is deferred adjudication. Deferred adjudication is referred to at the end of D. And all I'm saying here in this context is I think very careful attention needs to be paid to just dropping in the word finally when you've used throughout the rule period of probation. And everywhere I saw that, I thought you really intended to use the catch-all of community supervision, but then because it catches both, and yet you still have that deferred adjudication language up in D. And so there's a lot of potential unintended consequences when you start trying to define what is a final conviction. There's a whole body of law on that because you can use a final conviction to enhance an offense to another level of felony. So be aware of that. The one other thing, it's really kind of a gnat, but in D2, the 3 words under this rule in the first line probably need to come out because I'm not aware that there can be a felony under this rule. I understand what it meant in its original context, but I doubt that that's necessary to maintain.
Roger.
Yeah, that's in the original rule.
Roger, you're muted.
No, I unmuted myself. Well, I'm going to speak in favor of having some sort of presumption about a felony conviction. And I think what tips it for me is the public perception. To simply jettison anything about felony convictions being a bar or a presumption and just say, well, it's going to be a general weighing of fitness and character and competency. I think the public is going to say, what are you doing? A felony ought to be a big red flag. Now, you and I know there are felonies and felonies and felonies. But the public perception is felonies are very serious crimes. That's why we give them to district judges instead of somebody else, so on and so forth. So I think as a matter of restoring some sort of public confidence in who gets to be, at least to be considered to be a lawyer, we need to have some sort of presumption, if not a bar. And I favor the presumption because if that's what they're doing, people ought to know about it. I think the most important thing is to set some very objective minimum requirements to get a waiver, at least to make it look like people are being, the waivers are not being handed out willy-nilly or on a capricious basis. So that's my opinion.
Thanks, Roger. Frank.
I want to go back to finally. It does narrow the rule. It creates a loophole, and I don't think it's a good enough answer to say, well, we're creating a loophole, but we'll never use it. That's not what we ought to do in a rulemaking provision. As I understood, that was put in because we were getting rid of 3. I don't see anything wrong with 3. If it's reversed or if you get a pardon, the rule doesn't apply. The way we have it now is the rule doesn't apply if you haven't been finally convicted. I don't see any reason to make those changes. Take finally out. That way the rule applies to everything.
Hey, Frank. Harvey Brown.
I want to agree with Frank on that about the finally requirement. I think since it's a presumption only, that we don't need to say that. They can talk about in their application that it's on appeal and why they think they're going to prevail. So that seems to me that it would be something that they could consider, but we don't need to put in the rule itself. As to the rule itself, I think subparagraph 2 on the presumption could be slightly more clear for the non-lawyer who may be reading this. In a presumption, I would probably say something like creates a rebuttable presumption that the individual does not present, and then leave the rest as is until you get to the end. And then at the end, I would specifically reference subsection F, since I found that helpful when we did that just now. I think the reader would find that helpful. So I'd probably put at the end, subject to subsection F.
Great, thank you. Nina, finally getting to you.
Well, Justice Brown just said what I would have said, which is that I do think we can connect it up and say something about, and I like the change wording also, but I want to make sure Susan's comfortable, but make sure that D2 references that it can be rebutted, based upon considerations in Rule D4 or something like that.
Great,
so
thank you.
Right at the outset that there's a presumption, but there is a way to rebut it.
Great, thanks. Stephen.
Yeah, I think Roger makes a good point about public perception. Perhaps we should be more specific about what the board is considering when it's considering felonies, that there should be a reference to felonies, but there's no reference, I don't think, in there, Susan, to the nature of the crime. Is that right?
Not in the rule.
Right.
It's,
And-
we have some guidelines.
Right, but from public perception, well, they probably don't see any of this. But if they don't see any of it, then Roger's point is kind of moot. But if they do see this, we should reveal, if we're going to say something about possible rehabilitation from a felony, explain what that might be, which might be the nature of the crime. Or rather than a crime, nature of the felony, because that is something that you clearly take into account, and which is something earlier on I said was important because they're felonies and they're felonies, as Roger acknowledged. And then I want to throw a wrench into this by asking, is it a conviction if you get a presidential pardon?
I don't think it would be.
Okay, any more hands? I don't see any. And Nina, I don't know if a vote is in order at this point on subparagraph D, but if you think so, we'll vote.
Oh, based on my notes, I would like to go ahead and ask Susan whether, kind of going in order here, finally is a term that you're wedded to, or is there some flexibility to take that one out? It seems to have created some issues.
Yeah, no, we're not. I mean, I think that, the committee's vote on the overall intent of the revision is what's key here. That's consistent with our objective.
Right.
And, the details for how we best implement that, we're very flexible on that. And we spent a lot of time thinking about this and going back and forth about it. And I think it's, it's subject to difference of opinion about how best to implement it.
Susan, you have no idea how many hours this committee spent on the issue of finality.
I can imagine.
Well, I think, Chip, to your point, I have a sense of where the committee stands, and I've made some notes based upon the good suggestions here. And what I'm going to suggest to Susan and the court is something along these lines, and we can tinker with it, but to change D2, perhaps delete finally, and in D2 say, a felony conviction creates a rebuttable presumption that the individual does not have present good moral character and fitness, but that presumption may be rebutted based on considerations under Rule 4F or something like that. If that's okay with you, then I don't think we need a vote, but I'll defer to you on that.
Well, if you're deferring to me, that sounds fine. And if you're deferring to Susan, we'll see what she has to say.
That's a good point. And then let me also say, we haven't talked about 4F, but let's wait on that and finish on 4D first.
Right, yeah. I was going to get to 4F, but and Frank, we'll get to you in a second, but Susan, are you comfortable with us proceeding in that way?
I am. I think the board would be fine with that approach.
Okay, Frank.
Well, I would just say that if you're going to take out finally, I think you ought to put back in D3. I mean, I don't see any possible reason not to have a provision in there and saying if your felony conviction's reversed or if you get an executive pardon, this doesn't apply.
Yeah.
We'd still need to revise D3 because of the shall be permitted language, but that, that could be done.
Yeah, good point there, Frank. Thank you. Any other comments? Okay, no hands up. So we need to look at 4F, I think, right, Nina?
Correct. And then that will conclude it. And Susan, we'll let you get back on your vacation.
Yeah.
Appreciate your time.
So I think the changes to 4F are really reflective of the change, right, from conclusive to rebuttable, basically.
That's the intention, yes.
Mm-hmm.
Okay, any comments about 4F? Going once. Okay, I don't see any hands raised about that, so we will we will proceed on that basis. And I think that's it, isn't it, Dina?
That's it. And again, with great gratitude to Susan for helping us today and all of your guidance in this area. We appreciate it.
Wait a minute, 1 second. Justice Gray had his hand up. I don't know how I missed that.
Well, it took me a while to find it again.
So when I said going once, you were desperately trying to find the button.
I had my mouse in my hand. I'm going all over the screen looking for how to raise my hand. But what I'm, again, Robert's point about the and or appears in F, and the concept of community supervision, deferred adjudication versus probation runs throughout the rule. And I don't know if Nina is intending to hand it off and not do any further, come back with a draft with all the changes in it or not, but I don't care as long as the court is aware of the and or issue throughout the rule and the question of probation, which is a subset of community supervision versus deferred adjudication. So I make those comments so that they can evaluate that in the context of making any revisions to the rule, and specifically point out that on D2, you've got sort of the conflict, an individual guilty of a felony. It does not take into account in that phrase whether or not they're on deferred adjudication, which is a type of community supervision.
Well, so, I think we would take that language out under the revision.
Yeah. Well, if unless Jackie or Martha or the chief want to put this back on the agenda for next meeting, I would say we're done with this for now. And Nina, you can coordinate with Jackie and Martha about any tweaking that needs to be done as a result of this conversation. And Susan, of course, is always invited to participate in that. And Susan, I would be shocked if you don't want to stay for the rest of our meeting until 5 today and hear some of the discussion that we have about these rules. But if you have to leave, go ahead.
Well, I feel that I must. But I trust that you will have a very robust coverage of the agenda items. I'm not worried about that.
Yeah, I think we probably will. But thank you so much for joining us.
Okay. Thank you, Susan. Thank you for having me.
Great. All right. Pam, first of many appearances on our docket today, suits affecting the parent-child relationship and out-of-time appeals and parental rights termination cases. Judge Rucker of the Family Law Council had hoped to be here, but I think we got an email from him yesterday saying that he was unable to. I'm right about that, Marty? You're muted.
That is correct, Chip. He's not able to attend today.
Okay, great. So Pam.
Well, actually, Bill Boyce is handling this for our subcommittee, so I turn it over to Bill.
So Bill.
Thank you, Chip. So I'm glad you highlighted the letter that Judge Rucker sent as jurist in residence on behalf of the Children's Commission, because I'm going to lead off our discussion with that. And I want to highlight that letter to make sure that everybody is aware that that letter has been sent, because I think it highlights some policy choices that underlie the rule provisions that we've been discussing and tweaking and so on and so forth. So for purposes of today's discussion, I think the two things to have handy in front of you are the August 24th memorandum addressing appeals and parental termination cases. Subsection A of the discussion hasn't changed. Subsection B of the discussion, showing authority to appeal, has changed in the following respect. If you go to page 7 and 8 of the August 24th memorandum, you will see a draft Rule 306 that incorporates changes in an effort to address comments and suggestions that were raised at our prior meeting, our June meeting, regarding the mechanism for this proposed rule. I think Judge Rucker's letter is a invitation to take a step back and look at a larger policy choice that we're really talking about here in the form of rule provisions. So this is recounted in the memorandum. I'll go over it at a high level here, but you will recall that the HB7 task force had initially recommended a motion to show authority, or a requirement to show authority to appeal procedure for counsel in these cases that would roughly parallel Texas Rule of Civil Procedure 12, but would be specific to these cases. And the proposal from the task force was Texas Rule of Appellate Procedure 28.4C, certification by appointed counsel and motion to show authority. And the concept there was that there would need to be an affirmative showing that the desire to appeal was present on behalf of the parent whose rights were terminated. And I think there's two main considerations with that. One is the very legitimate consideration that the continuation of litigation, the continuation of appeals of termination of parental rights creates uncertainty and disruption in the lives of the children involved for as long as that litigation is ongoing. And that's a very appropriate and legitimate consideration. Going back to our discussions really into 2019 around this topic, I think that the subcommittee's discussion and then later the full SCAC discussion really focused on one of the practicalities, one of the realities of these types of matters, which is the potential difficulty of discerning the terminated parent's intent, in significant part because the terminated parent may or may not be reachable, may or may not be involved in the case, may come in and out of a case intermittently. And so a certification of authority to appeal in some ways presumes that you can locate and communicate with the parent at issue. And if you can't, then what happens? That was the discussion we had over multiple meetings, and that kind of morphed into the current rule proposal that appears at page 7 and 8 of the memo. And that is based more on essentially narrowing the circumstances under which an appeal is not going to go forward. And maybe the easiest way for me to think about this is as follows. We are having a discussion around this question, which comes up in a lot of different contexts. Which way does the silence cut? Okay. If it is not clear, or if there is not an ability to get a clear determination of intent to appeal, what is the next step? Do you have a rule that essentially says that the appeal is not going to go forward in the absence of a clear ability to convey an intent to appeal? And I think in general terms, that would be what I hope is a fair characterization of Judge Rucker's concerns and comments and proposal and the initial proposed rule. So does the silence cut in favor of saying that In the absence of an ability to get a clear statement of intent to appeal, the appeal is not going to go forward. And that's certainly a legitimate approach to this. It reflects the notion of needing to have a procedure so that litigation over termination of parental rights doesn't continue indefinitely. It dovetails with the time limits that the court has created for determining these types of appeals. It dovetails with the fact that these appeals are accelerated. In fact, they're very accelerated. So absolutely a legitimate policy choice and determination. Or are we going to have a determination that the silence cuts in favor of having the appeal arising from a constitutionally protected right to go forward, except in very narrow circumstances? The draft rule that appears in the memo reflects this approach, that unless somebody, an alleged father, has been completely not part of the litigation, the default is going to be that the appeal goes forward in recognition of the important and constitutionally protected nature of the rights at issue. And so I'm very cognizant that Judge Rucker is not part of the meeting today. I understand that Richard Orsinger was involved in these discussions leading to the letter. I don't understand him to be part of the meeting today, so I'm very I want to be very cautious about not failing to characterize correctly the concerns that have been raised. I'm giving you my understanding of where things are right now. And I think where things are in this discussion is that Judge Rucker's letter is potentially an invitation to talk about where the balance should be struck here between important policy considerations and important interests. Is it going to be struck more on the side of not having the appeals go forward, which may serve some interests of the children involved by not having prolonged litigation? It may serve court interests and court personnel interests in not creating what has been referred to before as the phantom appeals, where the appeal goes forward, records are created in the absence of clarity that somebody actually wants to appeal. That's a legitimate policy choice if that's where this committee wants to focus its votes. Ultimately, the policy choices are going to be for the court to make based on recommendations and input and its experience. Do we want to have the silence cut in that direction, or do we want to have the silence cut in favor of the appeal going forward unless there are narrow circumstances and good cause, however we want to define that? This rule takes a swing at it, but we can certainly have that discussion. However we want to define good cause for not having an attorney, an appointed attorney, stay on to continue with the appeal. And so I really sort of see that in light of this letter, there's a couple of ways we can approach this. We can take a step back and have this discussion about the policy choice that's reflected in the current draft Rule 306 that's been put out there for you. We may want to make sure that the input is heard in person from Judge Rucker, from Richard, or whoever else wants to participate in that discussion. I will confess to being a little bit uncomfortable with significant concerns having been raised, but nobody here to articulate them in person to you. And so maybe we wait to make sure that they can be articulated in person. Maybe we've crossed this bridge already and the time is most spent productively looking at the revised draft of Rule 306 and seeing if it works for the purposes that it's supposed to work for. The subcommittee will accommodate whatever direction the full committee wants to go in. My understanding and belief is that the current August 24th draft reflects the direction that the full committee has pointed towards over the last 3 or 4 meetings when this has come up. But nothing says we can't take a step back and reevaluate that if that's the will of the committee as a whole. And so with that introduction, I guess I would ask for discussion or direction about whether we want to take a step back and look at this larger policy choice, or do we want to drill down and talk about the pros and cons and the wording of a particular proposed rule.
Bill, let me ask you a couple of questions. Number one, I don't recall, is this something that we're under a time constraint on? Is this something that's got to get done right away?
I will certainly defer to the Chief Justice, but I'm not aware of a specific deadline that is, or statutory requirement that we have to meet.
Yeah. And the second question is, Judge Rucker until yesterday was going to be here. I don't know what conflict Richard Orsinger had, but is there any appetite to take this agenda item over to our next meeting and try to encourage one or both of them to be here?
We'll certainly be comfortable with that as the subcommittee. I think it's really the question to the full committee about how it wants to proceed with that.
I just got this letter a day or so ago and really haven't fully digested it. I doubt anybody else on the full committee has either. Frank, what's your thought about all this? You got to take yourself off mute, Frank.
Sorry. Small thought and larger thought. Small thought. Richard Orsinger's in mediation. I communicated with him yesterday, and he regrets that he can't be here. In the larger thought, one of the things that we've struggled with on this subcommittee is the fact that none of us work in this area.
Yeah.
We're all generalists. And so as a result, our fallback position for virtually every person on this court when you're confronted with this kind of question is due process. And so we're trying to give this parent who's about to lose his child every break in the world. But when people who work in this area come in, we see that there's really a countervailing issue, and it's a huge issue, and that is one, the fact is that the termination is probably going to be upheld. We're talking about the people whose rights we're trying to protect are showing that they're unfit because they won't communicate with their lawyer over this huge question. And so, and finally, of course, you think about the adoptive parents. As I understand, the child is in the possession of the adoptive parent while this appeal is going on. Am I correct? Maybe no one knows, but it's a huge thing. I mean, I can recall a tragic case years ago in Tarrant County where these people had adopted the child. They had the child for a couple of years, and the decree came down that they had to give it up, and it was just heart-rending. So all I can say is I agree with Bill. I think we need help on this. We need people who work in this area. They need to come in and tell us what they're concerned about. I appreciate the letter. I wish we had gotten it earlier, but it's really helpful that we got it in time. So I think I agree. I think we need to defer and get some help.
Yeah, thanks, Frank. One of the things that occurred to me, and Pete and Lisa, we'll get to you in a second. One of the things that occurred to me was, is there any data on how many of these phantom appeals morph into a real honest to God appeal? And that'd be an interesting thing to know. Pete.
I fully agree that we shouldn't go forward to a recommendation to the court without Richard. That's one of the two things that you need to know. You know, how does this play out with actual people, the clients and the people on all sides? And I just don't have a clue, and I wouldn't want it to make a recommendation without that. But the other key part of this is the impact as seen through the eyes of the judges, and we do have those here. And I'm wondering if it would be useful to at least have that part of the discussion here. If it is, the part I would be most interested in is, can any of you give us some examples of situations in which the putative father, let us say, shows up late and says, yeah, I do want to, and where we might be cutting something off that you think legitimately should have been considered, recognizing that that doesn't get you to the answer because you've got to weigh it against all these other things. But you know, that's the other part of what I don't know about that I'd like to have in mind. We could either do that now or wait until we have a chance with Richard.
Okay, thanks, Pete. Lisa.
I certainly don't think we're under any time gun that we can't defer this to the next advisory committee meeting. It's certainly important enough to. I have the utmost respect for Judge Rucker and where his heart is in this. We fall on different sides of it. I was on the HB7 committee along with Richard and Judge Rucker, and my partner Carlene is on the CPS will. So we probably do within our firm about, I don't know, I would guess 8 to 10 of these cases a year. So I'm certainly not as involved with them as Carlene is, but I definitely review every brief that's filed before it goes out. Justice Boyce has been awesome about reaching, even though I'm not on the subcommittee, nor is Carlene, but Justice Boyce has reached out to both of us for some amount of like practical consideration. And the problem is, to your point, Chip, about whether we have statistics or not, no, we don't. We have anecdotal evidence, which is kind of what House Bill 7 was founded on. And then we know that it's not just the parents' constitutional rights. Like parents, there are parent constitutional rights here too, but there are children's constitutional rights too. Children also have a constitutional right to a relationship with their biological parent. So the constitutional dimensions of this problem are twofold and might prompt someone to read Judge Rucker's email and think, I get it. You're a judge and a litigator, and you know rules work both ways for litigants. But we've always put children's rights above others and recognize that they're not really represented in the truest form. And so we make accommodations in our procedures to make sure that their own constitutional rights are protected. On the other hand, I was around when we started the Children's Commission. I was around when we got courts of appeals to have to decide these cases so quickly, and we implemented our own procedures. I 100% agree. And I think Justice Boyce said it 100, like his tee up of this issue could not have been more fair. There are countervailing policy choices on this. I just stand in a different relationship with Judge Rucker. And statistically, my anecdotal statistics are more of these cases come up where there is a participant at trial, but then they're hard to either get in touch with later or timely get in touch with later, which is its own problem. Like I can eventually figure out how to get to a mom or dad in prison, but maybe not within, it's not even 20 days because the appointment, an appellate appointment comes in sometimes even after the 20-day deadline, but certainly it gets really whittled down to where it's a matter of days and there's no, you get an order, you get no contact information about this parent. You have no idea even that they're maybe even in prison. You don't know what their mental issues are, and you're moving fast and as quickly as possible. But the safest thing that you can do is file a notice of appeal. But going back to the subcommittee's proposal, what I like about it that's different than what Judge Rucker's proposal is, and I might be getting too much into it, but it goes down into the philosophy of it, is it puts the onus on the judge when someone is in his or her courtroom to say, you have a right to appeal. You have a right to an attorney. If I need to know, I may be taking this under advisement, or we just got the verdict, or whatever what happened at trial. But in that moment, when you have someone present, you get an indication from them right then whether they think they're going to appeal it or not. That's probably anecdotally somewhere between, if I'm conservative, 70% of those cases up to, if I'm more idealistic, 90% of those cases. And again, this is just anecdotal, Lisa, not actual statistics, but it will take care of a big part of the problem where you have that moment to ask for the judge to ask the parent whose rights might be about to be terminated at that moment, what do you think you're going to want to do? Then once you get, but I think what Judge Rucker would rather do is put the onus on an appellate lawyer within 20 days to try to figure out how to get in touch with their client, which sometimes might be easy and sometimes might be almost impossible within that time frame, to certify in some way that this appeal is intended to be taken by the client. And to me, that's just, it is not the reality of my experience of our firm handling these cases over the last 2 years since Carlene has gotten on the CPS wheels. It's just, it's just impossible. And if that's determines whether or not this person has a right to appeal that affects the parent's constitutional rights as well as the child's constitutional rights, I am not in favor of it. Although I love Judge Rucker, and I agree that maybe we should pause and have a conversation where you can hear both sides of it, because everybody in this world has the best interest of these children at heart. And we lean one way or another, but everybody wants the best way to figure out how do you protect parents and kids and everything and have the best for them under our rules of civil procedure and appellate procedure that don't necessarily lend themselves to that. So that's a long-winded, Lisa, passionate way of saying that I would gladly defer to have this conversation when Judge Rucker could be here too.
Other than that, you don't have anything to say?
What?
Other than that, you don't have anything to say?
Exactly.
Good. Professor Carlson at one point had her electronic hand up, but it got lowered. Do you have anything, Professor Carlson?
No, I was going to echo what Lisa said, that we did speak with Carlene, and she did present a number of instances in which it was very difficult to reach the parent in a timely fashion.
Okay. Scott.
Thanks, Chip. I want to give a great hat tip to Bill for chairing this subcommittee. I'm on the subcommittee as well, and we have talked about this at length. And I, like Lisa Hobbs, I fall on the side of affording the greatest possible due process for this very sensitive legal issue. But I also agree that it makes sense to have some people who are in the trenches on this issue every day. So I'm in favor of putting it off till next time.
Okay. Well, I think the chair is going to make an executive decision and defer this until our next meeting. Marty, if I'm correct, that would be November 6th. Is that right? If you're going to talk, you need to take yourself off mute.
Yes, that's correct, November 6th.
Okay. And so I'm going to suggest that the chief enter an order commanding Judge Rucker and Richard Orsinger to be at the November 6th meeting. And that will prevent any mediations, court hearings, or anything else from interfering with our work. And so with that, in order to give Dee Dee a little break here and to give ourselves a break, let's take a 10-minute recess and then come back. Thanks, everybody.